Your Honor, it is my submission that this interview is about this matter. And I say so for 3 reasons. The first, Your Honor, is that immediately under the heading of the newspaper, there is the caption, Ogoti explains 150 million shillings bond. I submit that the Ogoti referred to in that headline is yourself, Your Honor. In the headline itself, it is corruption as bad as murder, says magistrate in governor case. I submit that the governor is my client, the first accused in this matter. Your Honor, in the body of the article, number 3. Number 1 is the banner that says Ogoti explains 150 million shilling bond. The second ground that I state that this article refers to this matter is the headline itself, corruption as bad as murder, says magistrate in governor case. This is the governor case in which you granted bond of 150 million shillings. The third reason, Your Honor, I attribute this article to this matter is the second paragraph in the main body of the article. And this is why I took the liberty, although I submitted, Your Honor, that I have no doubt that you're familiar with the contents of this article, to supply you with a copy of the article, so that we are on the same page as I had in my application. In the copy of the article that I have supplied to court, the second paragraph is marked 1 in the left-hand side margin. And that second paragraph, the author of the article states as follows. Magistrate Ogoti became a household name this week after he imposed stringent bond terms on the Samburu governor, and his name is stated in the draft case involving 84.6 million shillings. That is the context of this article. And I wish to submit that the sentiments that are expressed in this article and the sentiments, with your kind permission, that I wish to walk you through are in respect of this trial. And for reasons that I will demonstrate, it is my submission that because of many of these sentiments, it makes it untenable for Your Honor to continue to preside over any part of this trial. Your Honor, you are a duly appointed magistrate, and it is in that capacity that you are presiding over the trial. Your sentiments carry more weight than any of our sentiments, either individually or together. Because Your Honor has the responsibility of hearing this matter, ensuring that the accused person gets a fair trial within the full meaning of Article 50, as read with Article 24 of our Constitution, and all the other articles that are in our Constitution that pertain to fair trial. Yes. Your Honor, in the article that I have handed to you, I would now wish to refer you to the paragraph that commences with the number 2 in the left-hand corner. And you are then recorded as stating as follows. His commitment to fighting corruption becomes apparent as he explained how corruption wrecks a society, leaving beggars and helpless people everywhere. Your Honor, that is a strong view by a magistrate who is charged with the trial of this matter, about the substance of this trial. This is a corruption trial, and there is no contest about that. You are the magistrate that presides over the anti-corruption court in Nairobi. It is not a penal code trial. It is not a trial that contains offenses from any other legislation. It is a corruption trial of the nature that is referred to in the paragraph that I have referred you to. You then go on, and this one quotes you directly. Corruption is in the mind. It is an attitude. It has to be discouraged by all persons at all levels. People have to change their attitude on how to acquire wealth. Your Honor, that is a personal view. A very strong personal view. Whereas, Your Honor, it cannot be, your personal views cannot be regulated. But I submit that with personal views of this nature, you are not fit and proper to sit and determine this trial. For reasons that I will demonstrate later, the poor accused persons have been prejudged by none other, Your Honor, than the judicial officer who is supposed to try them. These are your views about corruption. These are your views about people who face offense. And I will demonstrate in a few moments how low that threshold is. How quickly Your Honor appears to convict accused people before you. Your Honor, at the bottom of the first column, I wish to refer you to the paragraph that has the number 3 to the left-hand side. You are quoted verbatim as saying, it has reached a point where people in charge of public funds are paying themselves in their names. That is a serious thing. Anyone handling corruption matters must speak loudly and clearly. Your Honor, I submit that in that paragraph, you are speaking to count 2 and 3 in this matter. Count 2 and 3 in the original charge sheet, and count 2 and 3, Your Honor, in the substituted charge sheet. This is not an idle comment. Your Honor, this is a comment that you have formed after reading the charges in this matter. Only the first accused person has taken plea. No pre-trial has taken place. Your Honor has had no evidence, but Your Honor believes that it has reached a point where people in charge of public funds are paying themselves in their names. And Your Honor then goes on to express a strong view that it is a serious thing. Anyone handling corruption matters must speak loudly and clearly. Only magistrates, Your Honor, I submit, handle corruption matters. Magistrates like Your Honor. Your Honor, there can be no clearer demonstration of a court that has made up its mind. If I may state, with tremendous respect, that whereas these views may be yours, these views may be properly held by yourself, but Your Honor, knowing that you are conducting this matter, it was most inappropriate, with tremendous respect, to express yourself as you did in this article. Judicial officers are never asked, and they are protected by the Constitution, they are never asked to defend their decision. No defense was sought of you of the bail that you granted. The first accused was dissatisfied. Properly guided by his legal counsel, he did, I submit, the right thing. In the same way, Your Honor, it is inappropriate for a court presiding over a matter of the nature such as this to give an interview. It is equally inappropriate for counsel to go and stand in front of the media outside court and say, we do not agree with what the magistrate said. It is inappropriate for comments to be made about matters in court by parties to those proceedings, by anybody else, and Your Honor, even less the court itself. will demonstrate shortly, Your Honor, that this, the mindset, the court's mindset that is evidenced in this article is a biased mindset. It is biased to the extent, Your Honor, that I submit that in this, if this trial proceeds before this court, then for all intents and purposes, the court and the prosecution are partners in this trial. The court and the prosecution, from the get-go, seek the same outcome. As I had submitted, Your Honor, it is as unprecedented as it is ill-advised. Your Honor, I wish to refer you to the paragraph in the second column that has the number 4 in the left-hand corner, where you are recorded as stating that Ogoti admitted that the DPP and the judiciary cannot fight corruption on their own. Prosecutions, he said, can never finish corruption. Your Honor, the DPP and the judiciary cannot fight corruption on their own. I submit, Your Honor, that the judiciary has no role in fighting corruption, with tremendous respect. As a judicial officer, you are a servant of the Constitution and the law. It is the prosecution's duty to bring evidence before you that proves to the threshold required by law that the offenses with which the accused persons are charged have been committed. That is the duty of the courts in this country, and that is your duty as a court, Your Honor. You have no agency in the fight against corruption. The court opens, the registry opens, the prosecution brings cases, and the courts then hear them. Your Honor, there is an image that I'm sure we are all familiar with. And it is an image that is commonly referred to as Lady Justice. It is the quintessential image of justice. It is the image of a lady with the scales of justice balanced in one hand and a sword in the other hand. And the important thing that I want to submit about that image is that Lady Justice is blindfolded. Lady Justice is blindfolded. Lady Justice epitomizes the court, and the court has no interest, it has no agency, and that is why that centuries-old image is blindfolded. Your Honor, I submit, with the best of intentions, that what I have referred to in the paragraph marked as 4 amounts to the removal by Lady Justice of her blindfold, and she then ceases to be an impartial arbiter. Your Honor, I submit that from the article, it is apparent that the court is determined to change certain mindsets about corruption. And I want to refer again to the article, because I have no other place to refer to. I want to refer to the article to demonstrate my submission. Your Honor, I referred you to, at the end of the paragraph marked 2, the paragraph where you state, where you are quoted as saying, corruption is in the mind. It is an attitude. It has to be discouraged by all persons at all levels. Now, I want Your Honor to look at that paragraph with the second sentence on the third paragraph in the second column, where you are quoted again as saying, the minds of people should be changed. The court should also be firm and communicate effectively. The minds of people should be changed. The court should be firm and communicate effectively. Your Honor, at the beginning of my submissions, I made what I believe was the irresistible submission that this article is written in the context of this trial. I submit that it is apparent from the paragraph that I have just referred to, read together with the earlier one, that the court is intent to change minds. And the court is intent to communicate that mind change effectively. Donna, it is a most unpleasant application to me, but you have the duty of creating a record of my submission. And I appear to be losing your honor. Yeah? I appear to be losing your honor. Please bear with me. To create the record.
And you appear to be
losing the court. Some of the things that I may say may be unpleasant, but they arise, Your Honor, squarely from this act. Your Honor, I wish to refer you to the bottom paragraph. The bottom paragraph in the second column that has the small 5 on the right-hand side. And Your Honor, this is the most disturbing paragraph. In that paragraph, Your Honor, you are recorded in this article as saying that he said the NYS suspects who are not before you and any other person, and Your Honor, charged with corruption is no different from a chicken thief. The elements of greed, charged with corruption is no different from a chicken thief, because the elements of greed and self-interest are the same. Your Honor, I have submitted that for me this is the most concerning paragraph. Because as reported by the journalist, Susan Muhindi, to Your Honor's mind, all you have to be guilty, and that is the parallel that Your Honor draws with the chicken thief. All you have to be guilty is charged. I had stated earlier on in my submission that I was perturbed as to the low threshold of guilt that is apparent in Your Honor's mind. We all understand the difference between charged and convicted. As reported in the article, all Your Honor requires for one to be greedy and self-interested in a corruption matter is for a person to be charged. And Your Honor, this is the reason that I have urged this application for recusal prior to the taking of plea. A charge sheet has been drawn and registered in court, and the accused persons I submit are charged. And to Your Honor's mind, they are guilty and they are no different from chicken, because Your Honor records that they are self-interested and greedy. Your Honor, with that kind of a mindset, it would not bode very well for the administration of justice in this country, for Your Honor having expressed himself so candid in such an extreme manner to continue to preside over this trial. Your Honor, I wish to refer you to the next paragraph, which I want to highlight. And that is the paragraph in the third column with the small 6 on the side. Your Honor is captured by the journalist, and here you were quoted verbatim, as saying, the poor man does not access resources effectively as the rich man does. Your Honor, there is a damning indictment against my, people in my profession here, but I will ignore it because I am not accused. You are then recorded as saying the rich man will hire a lawyer, change advocates, and waste time, hoping his case will fizzle out. The poor man comes to court diligently, but a thief is a thief. It does not matter who. Your Honor, a very strong conclusion. A very, very, very strong confusion about accused persons, about their advocates, and about their role in the conduct of trials in this country. Your Honor requires no reminding that in our judicial system, it is the judicial officer who controls the proceedings. An advocate may be holding here on a stretcher, but if Your Honor then does not give an adjournment, the matter will not be adjourned. Advocates are unable to delay. Advocates of well-heeled accused persons are unable to delay proceedings. The conduct of proceedings, the timetable for trial is squarely in the hands of the court. The last reference I wish to make to the article is the paragraph that is in the third column that is marked 7. Your Honor, I submit that in that paragraph you're quoted as stating that the job group of a senior assistant director of public prosecution and the chief magistrate are the same. Your Honor, for the accused person, and because I am on my feet this afternoon for an accused person, it is worrying where a judicial officer such as yourself has had a stint as a prosecutor refers to any role, function, or even pay grade from that judicial officer's former position of employment. Especially, Your Honor, when that former position of employment played a radically different role from what Your Honor is asked to do in this matter. You are not a prosecutor. You are not concerned with the evidence that is brought. You are concerned with hearing the matter, ensuring that the accused persons that the prosecution have brought to court attend court for their trial, and that what seems very remote in this matter, that is justice being done, is then done. Out of all the people in this courtroom, Your Honor, out of all the people in this courtroom, in the circumstances of this trial, it is only you, the court, Your Honor, that is charged with the responsibility of ensuring that justice is done. And it is up, Your Honor, at this stage to remind you, and I'm sure you require no reminding, that justice must not only be done, but it must be seen to be done. The perception of justice is more important than justice itself. You can have a completely unfair process, but that appears just, and the outcome will be accepted. In the circumstances of this matter, Your Honor, post this article, there can be no perception of justice being done. Your Honor, some guidance as you retire to consider your decision as to what considerations of law should guide your judicial mind as you retire to consider this decision is appropriate at this stage.